Good day, ladies and gentlemen. Welcome at day 2 of Betweenity's Conference on Africa Competition Regulation. It is great to have you with us. Thank you for joining us for this very, very interesting panel on questions regarding the tribunal's oversight, whether that is sufficient and appropriate. We are very blessed to have a very great team of speakers today. I'm quickly running through the list. Advocate Anisa Kessery, she's the advocate of the High Court and a former acting part-time member of the SA Competition Tribunal and a former manager of litigation and principal legal counsel of the SA Competition Commission. Jabulani Ngobeni, the head of case management of the SA Competition Tribunal, and he kindly stands in for Mondo, Chair Mondo, who is the chair of the Competition Tribunal. Thank you very much, Jabulani.
Thank you.
Then Advocate Oliver Josie. He's an independent non-executive director, and he's a former director of special operations of the Scorpions of the National Prosecuting Authority of South Africa, and a former deputy commissioner of the SA Competition Commission, and a former chief operational officer of the Competition Tribunal. Thanks very much, Advocate, for being here. And then Judge Thomas Okosun. He is a member of the Nigerian Competition and Consumer Protection Tribunal. And thank you very much, Judge, for joining us today on this very important panel of oversight. Section 49D of the Competition Act sets out the procedure for the settlement of contraventions of the Act between the Competition Commission and a party. When adjudicating consent agreements, the tribunal may confirm, indicate changes to be made in the draft order, or refuse to confirm settlement agreements between the Commission and consenting parties, and they must do so without hearing any evidence. One of the often cited cases is the Netcare case, and in 2008, the tribunal refused to confirm a consent agreement between the Commission and Netcare on the basis that the Commission had not given adequate consideration of the parties' inconsistent reasons, according to the tribunal, of their failure to notify a merger. And the matter was taken on review by Netcare to the Competition Appeal Court in South Africa. And the CAC disagreed with the tribunal's approach. It held that during consent agreement proceedings, the tribunal should accord due deference to the views of the Commission because it had conducted a full investigation. The tribunal's role is limited to the determining of whether a consent agreement before it is a rational one, serves to uphold the objectives of the Competition Act, serves to uphold the objectives of the public interest, and not so shockingly inappropriate that it will bring the competition authorities into disrepute. And in another decision, the matter involving the Commission and AECI, the tribunal argued that the consent agreement was indeed not rational because a penalty was levied without a theory of harm, and the tribunal granted the Commission and the respondents an opportunity to make further submissions, but the Commission eventually withdrew the consent agreement. Just a couple of quotes from the Netcare decision, and then we will start with our questions to the panel. The first one is the following. The consent agreement between the Commission and the particular respondent represents the culmination of detailed investigations of the complaint over a period of time. Armed with information at its disposal, the Commission is well positioned to evaluate the true extent and seriousness of respondents' misdemeanors. When it concludes an agreement of this nature, it does not do so lightly, but considers its appropriateness against the background of all its investigations. In my opinion, Counsel is perfectly correct when he submits that the tribunal should accord due deference to the views of the Commission. Then, another quote. What then are the circumstances under which the tribunal can interfere? As indicated above, it is not a mere rubber stamping. Another quote, the tribunal, of course, plays a most important role in the competition hierarchy. Another quote, as indicated, the tribunal cannot hear any evidence, but it can surely make such inquiries at the hearing as it deems fit in order to satisfy itself that the above-mentioned objectives are properly met. And regarding reference to previous tribunal decisions in the Netcare matter, the CIC was happy to confirm the consent agreement because, and I quote, the Commission took into account the tribunal's previous decisions on penalties imposed against parties for prior implementation of mergers. And I also take into account the important observation made by the Commission's representative that this method of calculation was in line with the tribunal's previous practice of taking into account the affected line of business. So this sets the scene for our discussion today, and I'm going to start with a question to Advocate Oliver. Can you provide us with an indication of the legal framework for the oversight role of the Competition Tribunal in relation to the Commission, with reference to all the laws that you are aware of, starting with the Constitution and the Competition Act and other sets of law? Thanks, Advocate.
No, thank you very much for that, Ms. Strydom. And let me firstly greet my fellow distinguished panel members as well. It's an honor to be with you on this panel. And thank you to the host as well for this opportunity, and greetings to all the online participants as well. This is quite an interesting discussion, and a very important one as well. I think at this stage as well, I think almost every weekend when you open the newspapers, there's something about the courts and the tribunals, etc. So I think it's an important one as well. Let me first start with a question, and which I will answer obviously myself as well, is why is oversight important? I think that's quite an important one to ask. And I think I'm kind of fortunate because I think my views today will be certainly very balanced. It won't be necessarily, taking the regulators kind of side, or because I also worked in the private sector as well for many years. So I see it from that perspective as well, in addition to the regulation as well. So the question is why is oversight important, especially in the context of the competition tribunal? And then we can go back. And I was fortunate enough to read a speech that was made by the former Justice of the Constitutional Court, Kate O'Regan. And we all know she was quite a prominent justice in this country. And she said a lot about separation of powers. And I think that's where it all starts, is separation of powers. And what she said in her speech is that separation of powers, firstly, is very entrenched in the South African Constitution. That's the first thing, although there's no absolute separation of powers. But those principles that we've seen from the 18th century, Montague's principles, is entrenched in our Constitution. That's the first thing. And the second thing is we must look at the purpose of separation of powers between, for example, the tribunal and the commission as well. It's checks and balances. It's to ensure that there's no abuse of powers, that the commission acts within the four corners of the Competition Act. I think that for me is the starting point. Then, look, I think this question, Odie, is such a broad question. One could have a workshop on this question alone, but I'm going to just touch on some very salient points that I think is important for this discussion. I think for me, the second point is to go to the Constitution to see what the Constitution said and what is the status of the Competition Tribunal. And then I want to touch on one or two of my own case law as well, just to support the argument that I'm making. So one must understand that if one goes to Section 166 of the Constitution, where it talks about judicial authority in the country, it does not include the Competition Tribunal. The Competition Tribunal is not regarded in the traditional sense as a court, although it's a tribunal for a specialist tribunal for dealing with competition issues, but in the normal sense, it's not regarded as a court. On the other hand, the Competition Appeal Court has the same status of a high court. So you can see already the difference between the tribunal and the competition appeal court. But that does not mean that the competition tribunal does not have oversight or cannot exercise oversight over the commission. It certainly can in certain areas that is very applicable to the Competition Act. Now, there's quite a few case law that I want to refer to, but look, for the interest of time, let me just touch on two, which I think is quite important. One is obviously the one that you quoted, Odie, the Netcare one, but there was another one as well that I quite like because this was a recent one. It was a Constitutional Court case. It was the Commission versus Group 5. And the reason why I'm quoting this one is because I know this one very well. if some of the listeners may know that Group 5 was one of the
Oh,
respondents in the construction cartel case, which was quite a big case during 2011 to 2013, and they were one of the respondents that did not want to sign a consent agreement. Other
yeah,
15 of the respondents signed, but Group 5 said, no, we're not going to, and we're going to take our chances in the tribunal and further on as well.
yeah,
But this case wasn't on the merits itself. This was more on administrative law.
yeah, yeah,
So Group 5 and the Commission landed up in the Constitutional Court, and the Commission's argument was that the tribunal had powers to review the exercise of public power, right? In terms of obviously Paja. And the long and short of it, the Constitutional Court came to the conclusion that the tribunal do not have those powers, and they looked at the current Competition Act. They looked at the various sections, in particular Section 62. Section 62(1) gives the Commission and the Competition Appeal Court certain exclusive powers over the Commission, but you will see the carve out is in Section 62(2).
yeah,
Right? It
yeah,
says that for certain matters, and there's about three grounds there, but the one important ground is the ground on constitutional matters.
yeah,
So when you look at constitutional matters, that power was reserved for the Competition Appeal Court and the High Court at concurrent jurisdiction as well.
yeah,
So you'll find that when it comes to the exercise of public power, for example, the Commission is not able to, the
sure,
tribunal is not able to have those powers clearly because of that carve out in Section 62. So when one looks
yeah,
at the legal framework, one can see that clearly from the Constitution that the Commission has limited power. So I think the question is always, when it comes to, for example, Chapter 2, Chapter 3, and Chapter 5, where the tribunal has those powers,
yeah,
right? And those are quite extensive powers, in my view. They're quite
yeah,
extensive powers to review, the exercise of the Commission's various roles when it comes to mergers, restrictive practices, etc., etc.
yes,
In my view, it's quite extensive. The last point I want to make is, which I think when it looks at consent agreements, because I think that's where most of the controversy
yeah,
is that one must look at the wording of Section 49D. And Jabulani and I know a lot about this because when we were in the commission, we were leading the team that was responsible for the amendments to the 2019, Competition Act. So we
yes,
know the kind of thinking behind what we want to achieve by those amendments in particular. Now, look, in my view, and I'm so fortunate because my previous background before competition law was criminal law, and so I know a lot about plea bargains because even when
yeah,
the Section 105A was being implemented, I was in the NPA at that time, the National Prosecuting Authority, and we were responsible for those amendments as well,
yeah,
especially with the Prevention of Organized Crime Act and the
yeah,
money laundering provisions as well. So they are very similar in nature. And you see, it was even quoted in the Netcare case by counsel
yeah,
as well,
yeah,
is that one must understand the reason behind settlements. When one understands the reason behind settlement, you could see clearly why the law was carved in a way that some of the discretion of the tribunal was curbed. They cannot hear further evidence because if you think about it, right, if you look at the wording of the act, is that the commission would have done an extensive investigation. They
mm,
would have satisfied themselves. Look, this is a case that is, perfect for settlement, and they don't want the tribunal to go into another process of almost re-investigating
yeah, yeah,
the case. So therefore, their discretion to some extent is curbed. It doesn't mean that they're rubber stamping, because what the court in Netcare said is that the commission
mm,
must still exercise its discretion. It must still look at public policy. It must still see whether the objectives of the act has been achieved, and it must still make sure that look, whatever is terms are in it is not so shocking that even the normal public will be outraged by it as well.
yeah,
So if you look at all those kind of things, in my view, I do understand sometimes I think the tribunal may or may not get the, the decision right in the end, but
Yeah.
that doesn't necessarily mean that they are rubber stamping.
It's just rubber stamping.
the
That's
consent
right.
agreements. Yeah.
Yes, yes. Thanks very much for that.
Let me leave it there because
Yeah.
I think I could speak the whole day on this.
And we can listen the whole day to you. Thanks very much, Advocate Oliver, for that great introduction. I think what I'm going to do is I'm going to ask Judge Thomas to quickly give us an indication of what happened in Nigeria. And if you can provide us with a short history of that case, Judge, that would be great.
I'm sure you're speaking specifically about the Coca-Cola case.
Yes, yes, that's right. Yes, yes, sorry.
So the Coca-Cola case was very interesting, but very intricate. But it was a 5 years investigation of Coca-Cola, the activities of Coca-Cola by the Commission and their own sister agency. You may not know, this is called Nigerian Bottling Company.
Yes, yes.
It was a joint investigation of their activities, and at the end of the day, they found there were a lot of infractions, one of which includes marketing a product, separate all kinds of products, but in similar manner, presenting it to the public, in other words, misleading the public to assume that Coca-Cola original taste is now the same as Coca-Cola original less sugar.
Yeah, yeah.
Instead of making a distinctive and clear advertorial and presenting them as separate as different listings, so that it was to the extent that people go buy Coca-Cola until they're drinking, they realize that, oh, this is different from what I was drinking. And then they had a point that they were advertised the same different products in the same manner, and to the extent that it became a public issue. But very interesting is that this investigation was not an investigation that the public wrote to FCCPC, the commission, to help investigate, but on their own, on their, what I would say, suo motu, they decided to investigate this matter for a period of 5 years, 8 presentations and all that, and the Coca-Cola had opportunity to make presentations and make reviews. At the end of the day, they made some very serious findings against Coca-Cola, and then asked them, now some of the things they asked them to do was that, okay, these are our findings, you have to do a robust advertorial, change this thing, distinguish the various products that you have so that the public are not misled. In the course of doing this, to be sure that you have effectively carried out these functions, you have to appoint a monitoring a mentorship, a monitorship for a period of 24 months to be paid by Coca-Cola, but such monitor must be approved by the commission. And then made some of the various editions. At the final end was that they then demanded because the law requires that for a fine, before you determine the cost of penalty for any penalty, you have to look at the financial, what is their audited account for the preceding years. So 10%, not more than 10% of their income, total income in the preceding years, your fine should not be beyond that. So they demanded for their financial books, which they tried to deny and said at the end of the day. But at the end of the day, they got it, and they fined them a sum of 180-something million naira, which is about less than $125.
Yeah.
Dissatisfied, they came to the tribunal to file an appeal.
Yeah.
Under Section 47 of the Act, challenging first the jurisdiction of the commission to even entertain or to have investigated. 2, that the commission have no powers to suo motu investigate them, since there was no complaint from any particular customer or consumer of their products. 3, that there is association registered NAFDAC, which is Nigerian Drug and Food Administration, that have approved their products, and that the Advertorial Registration Council have also, Advertising Advertorial Council have also approved the advertisement, therefore that the commission have no powers to investigate them and then make findings and then find them. And so they challenged the issue of fair hearing and order. So they challenged it and they came before us. So, but they forgot that there is section 104 of the commission, the act makes the commission the umbrella body of all regulatory agencies in Nigeria, meaning that whether you are NAFDAC, which is in charge of Food and Drug Administration, whether you are in charge of telecommunications, the commission in Nigeria is the umbrella body of that of consumer protection, consumer and competition matter in Nigeria. So when it dawned on them, they didn't know what to do. And then they raised the issue of fair hearing. And what is fair hearing? Fair hearing is that by the constitutional provision of section 36, it's very clear that whoever is being accused must be given an opportunity to make representation in order to defend himself. In the course of this investigation, it is evidently clear that the investigation was conducted, the Coca-Cola made presentation, they had a counsel represented them from every meeting, they submitted a document within this period of 5 years. And so now you are raising the issue of fair hearing. However, at the end of the day, they made their presentations, and then we concluded as to fix a date for for judgment after they have adopted their written addresses. But what happened? I think 36 hours before then, they filed what we call terms of settlement. And this was jointly signed. In both cases, in Coca-Cola case and the Nigerian bottling company, that was going on simultaneously. So, but we determined, we gave judgment on that of Nigerian bottling company 48 hours before that of Coca-Cola. So in the same, they filed similar terms of settlement where they made a joint statement that this is our agreement, and see if it was they are entering into a contractual obligations. And then we dismiss in that of the Nigerian bottling company that this is unknown to law. It is an attempt to arrest the judgment of the tribunal. So we refuse it. Now, on realizing that we have refused that, less than 24 hours, the next day, because we gave that judgment on a Monday, by Tuesday afternoon, they came and filed another one, which we then call consent order. Yes, section 149 of the Act makes provision for consent order. But there are procedures to be followed. Our consent orders don't give room for a joint statement or joint application. Now, don't forget, the appeal before us was filed by Coca-Cola, not by the commission. So the only persons or group of persons or individual have right to come and withdraw that case is the appellant and not the respondent. But they filed a joint statement as if they were entering into an agreement, a fresh agreement to withdraw a case. And we said this is unknown to law. Curiously, and most sad about it was that what were the terms that they entered into in that agreement? Very vexatious, because first was that they had agreed that, okay, the findings that what they found concerning the Coca-Cola, they were not vitiating those things as if they never existed, through that the penalty that they had fined them be changed from a penalty, because penalty follows the cause. That is no longer a penalty, but it's now cost, they can now call it what they call administrative cost of investigation.
Reimbursement.
How? Why would they take responsibility for your cost of investigation? So we looked at those applications and we again refused these ones because the principle, the law is very clear in section 149 as to what is a consent order. A consent order by our own interpretation and by our act must be filed only by the commission, not as a joint agreement. After you have investigated, carry out your investigations, make your findings as you find, present it before the respondent, who is now the Coca-Cola. That's what they have ought to do. presented, this is what we have found from you, this is what you need to do, we need to do this. Coca-Cola could have said, okay, we agreed with these things. We are going to implement what you have asked for. But please protect us and protect yourself. To protect us, make this as a finding. Why register it so that we would avoid the cost of litigation. When this is agreed, we know that you won't come back tomorrow or a few months later over the same matter, the same things that you have found, to now accuse us of the same thing. We're ready to abide and implement what you have found. In which case, the commission will then come under section 149 and file this. That is even before an appeal. In other words, there shouldn't be an appeal at all. But once an appeal has been filed, you cannot come on the same matter to come and say you are filing a consent order.
Consent, yes. Yes.
When this matter is still pending, it's not withdrawn, you didn't file any notice of discontinuance, and you can't even file that at the point of judgment because it is an attempt to arrest judgment. You would have filed that even before the adoption of your written addresses.
Yes.
Which you didn't do. So we again refused it. So
yes. I
will speak more as to really what is the procedure. The procedure, if you want me to elaborate on that, on the consent order, we did that first is that you have investigated, like I said, make your findings, but your consent order first must be in compliance with the Act.
Yeah.
2, it must be in public interest.
Yes.
If you find that Coca-Cola was producing or marketing different products in similar manner and misleading, you cannot wake up by a consent order and say it does not exist anymore. So you must make those things in public, that this is it, and so it must be in public interest. That's 3. What you cannot, by a consent order, even vitiate your own responsibility, because the Act makes it abundantly clear as to what is the function of the commission. If the law expects you to investigate and you now say, okay, we no longer investigate, how do you find a company guilty and you say they are no longer guilty? No fault. In fact, they use the word as if there was no fault, as if they have withdrawn those faults, what they found from this thing. So it's so shameful, and they are our sister agency because the commission and the tribunal is established by the same Act. In other words, that they ought to be an authority of these things and know how the tribunal would think. But we were utterly and totally disappointed, and when we realized that those who came with those consent orders, 3, like I said, it's not an agreement to be signed by 2 parties. It is only the commission that should come, that we have investigated these people, this is our findings, we have agreed, and they have also agreed we will have to present it so that you make it an order of the tribunal without hearing. However, though we have no right, we don't have to call any evidence, but we have the responsibility to look at it. Does it meet the basics, the standard required? Yeah. What are the standards? Does it meet the responsibility as a commission to investigate? Did you investigate before reaching this? What your decision, is it in public interest? 2, is it in compliance with the Constitution? Because if not, then you have just come to waste the time of the tribunal. The tribunal will not be used as a rubber stamp to just stamp this thing because it's coming from the commission. Yes, that is the position with the Coca-Cola. So what we then did was to refuse both the terms of settlement, which was filed like 48 or 46 hours before judgment, and then the new consent order, which you also filed like exactly similar to that of the terms of agreement, which is a terms of settlement, almost the same, almost 100% the same, except that they titled it consent order.
Something else, yes, and that's so, right. Yes.
This was
interesting.
What happened. But I can tell you clearly that as we speak, they are not appealing that case because they realize that there is no option, there is really no way out of it. They are not appealing the case, unlike that of WhatsApp. So both Coca-Cola and Nigerian Bottling Company have realized their mistakes and they have not found a way out, and so they are not bothering didn't bother to appeal this case, and they are not going to appeal the case.
Yes, thanks very much, Judge Thomas. That was indeed an interesting case, and which emphasized the importance of a consent order having to be in line with the underlying act, in that case, the Competition Act, and that's also the case here in South Africa.
I think Nigerian actually adopted a lot of this thing from the South, because
correct.
Nigerian is much newer than also new.
Yeah, that's right.
In Nigeria, so
yeah,
did a lot of copying, and well, don't use the word copy.
Yes.
Accepting some of the practices. You are much more advanced in this than in Nigeria, and so that is why even some of our very senior lawyers in Nigeria don't seem to understand that there is a difference between ordinary cases and competition matter in Nigeria.
Yes.
So particularly on the protection of consumers.
Yeah, that's right. Thanks very much, Judge Thomas. I'm quickly going to move to the area of merger conditions. Especially if we look at the Burger King case. Advocate Oliver mentioned that the tribunal does have some oversight, if I understand you correctly, Advocate, in relation to Chapter 2, 3, and 4. 2, 3, and 5. In other words, in relation to mergers, that is an area where the tribunal must exercise an oversight function. And in here, I'd like to discuss with Anisa the issue of the Burger King transaction. If you look at the wording of Section 16.1, which basically makes provision for any aggrieved party in an intermediate or small merger, they must request, or if they are unhappy, they can actually go to the tribunal, and they may request the tribunal to consider the conditions or the prohibited merger. And in terms of Section 16.2, it says the tribunal must consider the merger in terms of Section 12A and the particular request or the recommendation, where that request refers to the request for consideration or reconsideration. And it was just so interesting because in the Burger King merger, the Commission initially prohibited that merger, and that was on the basis that there was a loss of about 68% of HDB shares that would have been lost. And the merging parties referred that to the tribunal. And the tribunal adopted the position that the Commission will only consider the conditions. They will not consider the merger de novo. And my reading of the Act is that they actually have the obligation to consider that de novo because they have to consider the entire 12A. So, Anis, if I can ask you, considering this wording, is it correct to argue that the tribunal can only consider the remedies and without having to consider as part of that request for reconsideration or consideration, as opposed to only considering the conditions? And I'm going to phrase it a bit broader because one of the issues that was quite apparent from a commentary perspective afterwards was the relevance of the Shell TEPCO transaction, which basically mentioned that it's not necessary for when there's a loss in HDP ownership to replace it, to make sure that all HDPs can realize a return on the investment. And the issue was the merger was prohibited basically based on those grounds, that there was not a making good of the loss of HDP shares. Was this not an ideal opportunity for the tribunal to give much more guidance and to ventilate that issue to a much larger degree? If you can give us your thoughts on that merger, I think that is quite important for us to consider from an oversight perspective.
Thanks, Odie. I want to start there, but before I start there, I just want to start somewhere else, if you allow me and give me a little bit of leeway to do that. I want to start off first with the use of the word oversight, because I think it's incorrectly used, because oversight tends to indicate that there's some level of overseeing the work of the Commission, and that's not the case. And that's where even the Nigerian appeal court, as well as what Oliver said, comes into play here, because there is a separation of powers that we cannot ignore and we must not ignore. So the Commission is the role of the tribunal as an adjudicator is to then independently, impartially, after reviewing all the evidence before it, come to a conclusion as to whether a transaction ought to be approved, whether without conditions, what those conditions are, whether the conditions work, etc. And my understanding is, and I'm not saying that I agree or disagree with or I come to a conclusion on whether there is actual rubber stamping, etc. What I'm trying to say is every case is considered on its own merits on a case-by-case basis, and bearing in mind that the role of the tribunal is not an oversight, but it is to be an impartial adjudicator. So I wanted to start off there because I think that that is a very important distinction to make.
Correct.
And then to go to, so to get to the Burger King case particularly, and I'm not privy to all the background details or whatever is not redacted from the public version that's before us, but it doesn't escape me that the first thing that was said up ahead is that we afforded an opportunity to the Commission, to the DTIC, to the union, and the parties who had participated in the investigation to indicate whether these revised conditions address their concerns and to indicate their views in this regard. And then the Commission indicated it was satisfied, the DTIC indicated it was satisfied, the union asked for further clarity, and that was the way the whole matter unfolded. So I think it's a bit narrow to say, we decided we're only going to look at the terms as was agreed, because it has to be looked at in that context, which is there was a whole lot of debate, there was a whole lot of arguments, there were a lot of toing and froing between the different parties, and it ultimately resulted in the set of conditions that was put before the tribunal, which the tribunal then interrogated. And that brings you to the, or rather me to the important point of what is that interrogation, because we see a particular position that the tribunal takes when it is at the hearing. What we don't see is what might be going on in the background. And as Oliver said, I'm also in that fortunate position to be able to say it from both sides, from the tribunal, even from the Commission side, and having sat as litigator there and then now as counsel. And so I can say that cases are evaluated on a case-by-case basis, and they are interrogated, and the questions are asked. But what I can throw out as a little bit of a controversial question is whether there's sufficient interrogation of what comes before them. And that on that, I just want to take it a little bit further to say, okay, so where we are is we have different types of things that appear before the tribunal. You have conditions in mergers. You have settlement agreements that are brought in, by parties, and then you've got consent, which are made into consent orders. Now, the act, the section 49, which Oliver was referring to, which you also referred to, and when you talk about it against the Netcare case, it must be borne in mind that what it's saying is you can't have this new evidence, but it's saying you may confirm. So it doesn't say you must confirm. So it says the tribunal may confirm. And in that may is the discretion that the tribunal has to apply its mind to the evidence that's before it and the record that's before it in order to decide, must I confirm this? Must I not confirm this? Or must I change it in the form that it is? And so the tribunal has done that. We have seen them do that. We've seen them say to parties, no, hang on, you have brought this, you're saying that there is no contravention, but why did you conclude the settlement agreement? Tell us what led to this. There's nothing in the consent agreement that speaks to the Commission's investigation, to what the Commission found that led to the consent agreement, and we need to understand that. I mean, in 2014, Takalani Madima said publicly, although he ended up confirming the premier fishing penalty of 2%, and he said, we are not a rubber stamp. He used those exact words. He said, we are not a rubber stamp. We are here to interrogate. And I'm not saying I'm not going to confirm it, but I'm saying, parties, you need to persuade me that this is a sufficient deterrent penalty and that I must accept this penalty. And so to start off there, we know the tribunal is on a level interrogating what comes before them and deciding, well, should we or should we not approve it? Where things are going slightly controversial and slightly need to be considered even further is this issue of what's called a sweet deal. So what we have is sweetener, and if I can go to what was said last year, sorry, just forgive me, I'm trying to plug in quickly. I apologize, I didn't see that. Okay, I'm done. So what the chairperson of the tribunal said last year in the annual conference, if I can just say a little bit of what she said, a developing trend in mergers is an increase in sweetener conditions proposed by parties to get the deal through. And then she gave examples of what these sweetener deals are, such as free surgery, performing free surgery, addressing surgical backlogs in public hospitals, financially supporting the upgrade of clinics and mobile health units in underserviced areas, commitments on human rights. And we saw those commitments on human rights in the Heineken merger. And we've imposed these conditions, and our approach has been to satisfy ourselves first that they are indeed competition or public interest issues. And thereafter, we consider whether the conditions could be said to be shockingly inappropriate and if the conditions contribute to a positive change in society. And we've imposed and tightened the conditions to ensure enforceability. The benefit of our competition law regime is that these public interest considerations are done transparently and in public hearings. And I raise this because it is well and good. It is great to have sweetener deals. But the controversial question is, are these deals, such as commitments to relieve surgical backlog, related to the public interest issues? Are they related to the public interest issues? And there are 5 that are set out in the Competition Act under Section 12A3A2. A2E. So the question is the tribunal properly applying its mind to these conditions that have been undertakings and commitments given to get the deal through? And then the second question is, in the tribunal saying, well, I approve of these and I'm going to make them an order of court, is the tribunal not saying to parties, well, this is an implication or a suggestion that if you bring the sweetener deals through and to the commission and to the DTIC such that they have no objections to this deal, we're going to approve this transaction. And that is quite a risk that needs to be considered. And because by the tribunal then saying, I'm going to approve this and make this an order because it's not shockingly inappropriate and it's to the benefit of public in some way, even though it's not directly related, is the tribunal ignoring the fact that parties are not in a level playing field when they come before the tribunal?
Exactly.
That they have to agree to certain conditions in order to get this deal through.
And sometimes with a prohibition already over the head, like in Burger King.
Prohibition already over the head. But I want to take that back. And I want to say, but surely the onus is not just on the tribunal. It is also on the parties to say, hang on, we don't agree with this. We are before you, but there is no competition issue. And that's where the tribunal's role and discretion must come into play. Not simply to say, I accept this, but to say, let me interrogate and probe what the origination of this was, such as what happened in Coca-Cola. Coca-Cola said, we're going to look at how did it originate? Is it within the act? Is it within the Constitution and consistent with the Constitution? And it mustn't be that this agreement becomes a conduit for something else. So those are the probing questions the tribunal must ask. And it is obliged to ask those questions to say, how did we get here? Parties, you've agreed to this, but have you agreed to this with a sword against your neck?
Yeah.
You know, because you don't want to, and it is really important to maintain the impartiality and also to make sure that you don't deter investment by saying, well, in order to invest in this country economically, you must be able to and ready to agree to things that are not even related to the transaction.
Yeah.
And then that brings me to another question. What happens when these commitments are not honored and they are an order of court? I mean, the tribunal it's equivalent to an order of court. What do you do? Do you unbundle? Do you divest? Do you say, I'm going to now impose huge penalties? But how do you ensure that these commitments are actually honored? And so there are a lot of questions. I want to leave it to say there are a lot of questions that I believe need to be answered. There is case law in South Africa on appeal. There's appeal that says, you know, we encourage appeal case law that says we encourage settlement agreements.
Yeah.
We're not discouraging it.
Yeah.
We encourage settlement agreements because that's a way to get things done quicker. The question is, though, and the important thing, and sorry, I wanted to say that that's also a difference in Shell TEPCO, because in Shell TEPCO, which was in 2002, they spoke about, you know, the tribunal spoke about the fact that we can't disregard competition and in favor of a historically disadvantaged person's interest. But you must remember there that in that case, the parties had given evidence that they did not agree with these conditions.
That's correct.
And these conditions actually changed the structure of the deal. And that was important to considering whether or not to approve the transaction. And that's important consideration in Shell TEPCO. But what I wanted to say is, so the tribunal, when it applies the test on public interests, must apply in mergers, must apply in terms of what's set out in the law. It must not go, in my view, must not go beyond the law. And then the question is, well, what do we do about the sweetness?
Exactly.
And the question is, should they actually form part of a consent agreement? Commission's tribunal's view, and Jabu might speak a little bit more to it, is, you know, it's not shockingly inappropriate. It doesn't harm public interest, so why not include it? But then what happens when it's not honored? And I really, I was really taken in by some of the things that were said by the tribunal of the Nigerian Competition Tribunal, which said, you know, you must apply the law. You can't act beyond the law. You must ensure that in exercising your discretion, you exercise it in what's within the confines of the law, which is what is in consistency with public policy as well. And you must ensure that the Constitution is also protected. And the Constitution protects the right to fair access to and an impartial hearing. And so you must be able to protect that. And as a tribunal, you must ask the questions that ensure that parties are not on an uneven playing field and haven't just agreed to conditions for the sake of getting a deal through. And I do believe, I must preface all of this by saying, I do believe that the tribunal does that. It has 3 panel members. The 3 panel members are always appearing with different views because everybody has a different view. And whilst it might seem like everybody concurs all the time, because that's what you hear, you're starting to see some dissent. There's already been one dissenting judgment, and as far as I know, there's another dissenting judgment that hasn't been published yet. But there's dissent where the tribunal panel members are saying, what is the purpose of this condition? The parties are saying there was no competition concerns, so why should I accept that a condition must be included.
Right.
So that is the way forward. That is where it goes. You apply your discretion, but you do it in line with the Constitution and the Act.
Yes, thanks very much, Anisa. That's very insightful. Jabu, you are welcome to comment on Anisa's question, and I'm just going to raise something else as well. And this was something that we picked up, and it was in the context of a market inquiry. And you will recall that the tribunal, or that the commission asked Pick n Pay and Shoprite to change the exclusivity provisions in their contracts, and they provided an end date in the consent agreements. And for Pick n Pay, they set the end date as 2026. But for Shoprite, it was determined to be 2024. And I think it was last year or the year before, the tribunal was asked by Shoprite to change it so that they are not being disadvantaged in relation to Pick n Pay. And the tribunal said it's fine. We will order that change. And interestingly, the tribunal said, as part of that decision, we also cautioned the Commission to, in the future, carefully consider the potential implications for competition in markets for entering into disparate consent agreements with different market participants stemming from the same market inquiry. In addition to allegations of potential distortions of competition in the market, disparate consent agreements may lead to the undesirable situation where parties, specifically those that are first to contemplate settlement, are deterred from voluntarily entering into consent agreements. And the interesting thing for me wasn't it the purpose or the responsibility of the tribunal to pick up those differences? And why did it approve two things that would have this effect of potentially deterring or the chilling effect on settlements? Because the advice that they give the Commission can equally apply to themselves. If you can address this issue and then anything in relation to what Anisa said, that would be great.
Yes, no, thank you so much, Odie. I mean, I wanted to just maybe comment on the last point that Anisa was dealing with, which is the Burger King issue. And I think the question there was posed, and I hope I'm correct in terms of how I am, rephrasing the question. The question has been that the interpretation that was adopted in Burger King seems to be in conflict with previous tribunal decisions or previous tribunal positions adopted in Shell, TEPCO, and other judgments. There, I just wanted to say, without wasting time, that there is no conflict at all. And I think I just thought maybe I should indicate that those decisions which you mentioned are decisions which were decided before the amendments of the Competition Act in 2018. And the purpose of those amendments was just to strengthen our public interest provisions and to accommodate a wider consideration of public interest insofar as they involve, small firms and also participation of historically disadvantaged firms. So I thought maybe I should just clarify that there is no conflict at all. I think in terms of the question that you've just posed, which goes to the consent agreements that you've spoken about, which is the disparities, you framed the question as the disparities picked up in the two consent agreements, which is the Pick n Pay and the Shoprite consent agreement. I think, just before I deal with that, maybe just to indicate that I think I'm one fortunate person having worked with all three chairpersons of the tribunal. And I don't know if there's anyone else in South Africa, but I was very fortunate. And I mentioned that because I've been exposed to the kind of things that Anisa was talking about, where, she spoke about work which happens behind the scenes, work which happens, the preparation that goes on to these hearings, and what the tribunal does in terms of firstly communicating with the parties, and that is part of the hearing, communicating with the parties before the hearing starts. I mean, the lawyers appearing before the tribunal will tell you that there are extensive information requests which are circulated and they are sent to the parties before the hearing. That is done. I mean, that has been done when I first joined the tribunal, when I came back now, and that is done in each and every consent agreement or settlement agreement. So as a result, I think any perception that is out there that, to the contrary, that the tribunal overlooks or maybe rubber stamps and all of those things. I thought that maybe I should just, make a couple of remarks before I go to the Pick and Pay and ShopRite consent agreement, just to dispel those rumors or maybe that perception. And I think if you look at what the tribunal has done, and I just wanted to start with a case which Oliver has actually worked on, in consent agreements where the commission was involved in this fast track process in the construction sector to try and settle what we refer to today as the construction cartel, which involved the building of stadiums just before the World Cup. I think those who've worked on those cases will tell you that the construction settlements were all subjected to a rigorous interrogation by the tribunal to ensure parity, because you were dealing with various respondents, and there were many of them, and the tribunal had to ensure consistency and fairness in terms of the methodology which the commission was actually applying in settling with the various respondents. That is the first thing I thought I should mention. Right. And those who've worked on those cases, they will actually tell you that that's exactly what happened. In the other case that I thought maybe I should mention, in the furniture removal cartel, which involved various companies, there were many of them. Again, even there, those consent agreements which were brought to the tribunal, before they were confirmed, they were interrogated in terms of each of those, clauses, and to try and understand the potential implications and the differences between the various consent agreements before confirming them. That was done before the hearings. It is done during the hearings as well. And more recently, the tribunal has actually sent back consent agreements to the commission. And I mentioned just one, which is the Golfers Club consent agreement, where the tribunal had actually queried, the rationale, firstly, for the explanation for the non-admission, and actually whether the conduct, of the respondents was actually a cartel conduct. And we also, as the tribunal questioned the appropriateness of the monitoring provision, which required the respondents to provide the commission with reports on prices at which golf clubs were to be advertised, together with those discounts. All of that was done, and the consent agreement was sent back to the commission for the commission to actually deal with the issues and for the commission to actually fix and attend to the tribunal's queries. This is even before the consent agreement has been dealt with. So that consent agreement came back, and the commission had actually addressed all of the tribunal's concerns, and the consent agreement was ultimately approved by the tribunal. Yes. There was also another consent agreement, and it involved two entities. I mean, it's called the Robert Quarry and Shelf Corp consent agreement. There were two of those consent agreements. The commission had found that Robert Quarry and Shelf Corp's conduct had amounted to collusive tendering. So they had actually been accused of collusive tendering, and the commission had entered into two consent agreements with those two entities. Both those entities did not admit liability before, when those cases were brought to us as consent agreements. The tribunal rejected that consent agreement. Firstly, before it rejected the consent agreement, it posed various questions to the commission at a hearing, and the commission was told to try and address the tribunal's queries in that particular consent agreements. They were sent back, the two consent agreements, and ultimately, when the commission resubmitted those consent agreements, the tribunal was still not satisfied with those two consent agreements, and the tribunal rejected those two consent agreements. And there are reasons which were provided for the rejection. And because one of the reasons was that the tribunal found in those reasons that the parties, which is Shelf Corp and Robert Quarry, were not necessarily competitors in the true sense of the word, because both of them were owned by the same person.
Yeah.
And the commission was of the view that they were separately incorporated firms, but the tribunal disagreed. We rejected the consent agreement, and that matter was not appealed. So I think those two, the picture which I've just painted to you shows, it paints a picture of a tribunal which engages with consent agreements. It paints a picture of a tribunal which does not at all rubber stamp any of these consent agreements.
Yeah, definitely.
And I think coming back to the question that you've just raised in terms of the two consent agreements that you've raised, which is the ShopRite and the Pick and Pay ones.
Yeah.
I thought, I think with the ShopRite consent agreement, and if one goes through, and I don't want to take much time on this one, if one goes through the transcript of that consent agreement, the first thing that you're going to pick up before the hearing, there were indeed questions which were posed to the commission and the parties for the commission to address various issues, which ultimately are issues which you're going to see when you look at the variation application, which you're now referring to, are issues which were ultimately the focal point of the tribunal before the confirmation of the ShopRite consent agreement. And when the commission appeared before the tribunal, there were questions which were posed before that consent agreement could be approved. Questions on the explanations of why supermarkets enjoy, we're going to enjoy protection in non-urban areas, and the impact on small retailers, and whether small retailers, are going to be treated differently by being excluded from the protections that which were extended to supermarkets. All of those questions were posed to the commission.
Yeah.
And if you go through the transcript, you're also going to pick up that the commission does concede that they actually made adjustments to those consent agreements on the basis, firstly, of the questions which were sent to them by the tribunal prior to the hearing, which shows the tribunal's interrogation and not the rubber stamping, the interrogation of the consent agreements before they come to us. And again, which also shows that the commission realized that the tribunal was indeed correct in terms of the questions that it had, and then they adjusted those consent agreements, and then it came back, and then the tribunal was satisfied. Applying the Netcare test, the tribunal then confirmed that consent agreement. What then transpired, Odie, is that when the Pick and Pay consent agreement came, and again before the hearing, there were questions which were sent to the parties. During the hearing, the tribunal again, interrogated the consent agreements. And one of the things which the tribunal asked, and if you look at the transcript, and there were no reasons because it was a consent agreement, but the transcript is very helpful because it records the proceedings and everything which transpired before the tribunal. The tribunal asked the question to, Pick and Pay and the commission, the issue of the 2-year difference in the phasing out period between the two consent agreements. That was asked. The tribunal asked whether the terms of the consent agreements which were now being adjudicated upon by the tribunal, whether they were shared with ShopRite. That was a direct question which was sent to the parties and also to us, to the parties, before the hearing and during the hearing. The tribunal also asked Pick and Pay, why the Pick and Pay, consent agreements, unlike the ShopRite consent agreement, made provision for the ending of exclusivity in new leases, but it allowed Pick and Pay to incorporate exclusive provisions when it renews existing leases. That was a question which was directed at the parties. And the tribunal also asked, why Pick and Pay had, why the commission had agreed that Pick and Pay must, stop exclusivity in respect of HDPs, where ShopRite had agreed to immediately stop enforcing, exclusivity provisions in any other supermarket, in shopping centers specified as either, non-urban and all of those things. So I think I'm painting that picture just to indicate to you that the disparities that you pick up were important disparities in the consent agreements, and they were explained by both the commission and Pick and Pay when they appeared before the tribunal, and they were accepted by the tribunal. But in any event, I think even if one were to assume that the disparities were inappropriate. The case law standard is very high, and that is the standard which Oliver has spoken to, which is shockingly inappropriate.
Yeah.
And I think in the view of the tribunal, there was nothing in those consent agreements which had given or rendered those two agreements to be shockingly inappropriate. And as a result, after having considered, the two consent agreements, the tribunal then confirmed the two consent agreements, with all of those amendments which were then added after the tribunal had sought to strengthen some of the clauses to ensure legal clarity and to ensure that there is no dispute in the future.
Thank you.
Thank you.
Yeah, thank you so much, Jabulani. This has been such a wonderful clarification. We are running out of time, so I'm going to ask each person just in 1 or 2 minutes just to quickly provide a key thought that you'd like people to go away with, whether it is assurance or whether it is a flag, anything in relation to the tribunal's oversight, or as Anisa said, its adjudicatory function in relation to the Commission. And maybe just the last thing, if you can address this in your last response, is the question of imbalance of power. I'd like to hear from Judge Thomas and Advocate Oliver and Jabulani and Anisa, just in relation to that issue, because, for example, in merger context, merging parties are under time pressure, so they will not always appeal, especially intermediate mergers. They will not always go to the tribunal. And is there a higher standard of care to make sure that in those instances there is also sufficient guidelines for the Commission to proceed? Thanks very much. Let's start with Judge Thomas. Maximum, let's make it 1 minute each. Thank you. 1 to 2 minutes.
Okay. I thought we could do more, but let me state this. When matters comes before me and counsels appear before me, I usually say to them, they are not the one on trial, that we are the one on trial. Because the reality is that parties know the truth. Wow. But they want to see how they can navigate through in order to get favor get judgment in favor of their clients.
Yeah.
But they always know the truth, either by case law or by the provisions of justice, except very few that do not know. That is the reality. So the people who are truly on trial is the tribunal. And that's why when they come, like we said, for example, the commission, when they file their terms of settlement or their so-called consent order, would have thought that because we are the same, this thing created by the same act, hook, line, and sinker, we have approved what they have asked for. But that's not the truth. Because you must work within the confines of the law. If you are in breach of the law today, you might suffer the harm tomorrow.
Yeah.
You could be the victim. Now, you talked about the issue of merger, acquisition, whatever it is. The key thing for me that you must look at is it to create dominance? Is it to create monopoly? In whose interest? Will it protect competition? Because the essence of the Competition Consumer Protection Commission is actually to protect consumers. Yes, while you are also promoting investment. So if you also have a measure that will wipe away the other smaller competitors in the society, these are things that you have to look at. So there are a lot of things that you look at, and no measure can be the same. Just the same way that no two cases can be the same.
Yeah.
The example I gave to you, for example, Coca-Cola case and Nigerian bottling company were jointly investigated. When both came before us, I asked them, I said, why don't you file a joint appeal? But the counsel didn't want it. One was ready, the other wasn't ready, because that would have done them a lot of good. But he refused, because every lawyer wants to earn his income. The other wants to earn his, I can't stop them from doing so. I said, okay, let them then take them case by case. And that's why what they filed before us was the same, exactly the same, word for word. But because in their own terms of agreement, let me tell you this, this might be very important. Let me just read part of this to you and I will copy. One of the this in the end was that the Commission and Coca-Cola irrevocably agreed that all parties, all penalties, fines, and directives contained in the final order and the supplementary order are by this order rescinded, withdrawn, and vacated. How can a tribunal that is what it sought accept such a thing?
Mm.
Two was that you can't, by a consent order, withdraw a case that is not filed by you. The commission didn't file a case filed by Coca-Cola, and you are coming by a consent order to withdraw that. You can't. It's against jurisprudence in Nigeria. I don't know whether they do that in other climes, but not in this country. It's against our constitution and all that. So for me, I think that it is something that needs to grow, that we need to encourage and let the tribunal remain totally independent. Like she said, the tribunal is not an appendage of the commission.
Mm.
It is not a supervisory body for the commission, because it is only when the commission or an appellate, somebody, an aggrieved consumer or any person feel aggrieved that can come before us. So we don't persuade them, we don't direct them on what to do. Only one instance have Nigerian tribunal have a case to do so, because we received a petition, public petition, that a small company, a bank of 2 years, wanted to acquire one of the oldest banks in Nigeria through a fraudulent means. And then the commission closed its eyes to it. And then we wrote to the commission that they must investigate this matter. The investigation led to the fact that there was an undertone, an attempt to, by some powerful Nigerians, to take over the big bank using a smaller bank. And today that stopped. That frustrated the effort. That was the effort of this tribunal. And so for me, it is how much we can contribute to the development of this country, and it should be done everywhere, irrespective of whose horse it's built. Not about who is president, who is bringing the matter before you.
Yeah.
Obey the law, follow the law, hook, line, and sinker, and then you do what is right for people. And then every country will be better for it. Because otherwise, you might turn out to be a victim tomorrow.
Thank you, Judge. Thanks very much for that. Advocate Oliver, what are your parting words?
Yeah, no, thank you very much. I want to sort of answer this question somewhat slightly differently. I know my colleague, Mr. Ngobeni, won't be able to say this, but since I'm an ex-employee, I can say this. So I think for me, what people on the outside who haven't worked in the commission or in the tribunal, and I also want to show off a little bit as well, like my colleague, look, I worked with 2 chairpersons and 2 commissioners as well. And the one thing I can say is that the lessons I learned is that those chairpersons and those commissioners were very committed, I must say, to promoting competition and the public interest. I can tell you that. And I don't know, the last chairperson I worked with, Ms. Mazwai, very, very committed to the public interest. And even when we used to report as well, I remember our quarterly reports, our annual reports to the minister as well.
Yeah.
You know, she would personally look at that reporting and she would add inputs around the public interest. What was the impact of the tribunal as well?
Yeah.
But that's not the point I want to make. The point I really want to make in this 1 minute is that people don't appreciate that, especially for merger control, those timelines are very short.
Yeah.
Unlike, cartels and abuse of dominance, you've got years to investigate those. Especially for merger control, is that, and I know when I was in the commission, on an executive level, we used to meet every Tuesday, and there was these liver arch files that you had to go through over the weekend and prepare for the Tuesday meeting because you're making decisions on mergers as well. And we used to ask a lot of questions to the merger control team.
Yeah.
And they have to go back and have to research and fix this and fix that, etc. Same in the tribunal as well. And I really feel for Jabulani and his team as well, what they used to go through, the long hours that they used to work. I used to honestly sympathize with them, from a wellness point of view, the long hours they used to work. Vacancies in the department as well, and trying to replace those officials. The one thing people don't realize is that the turnover rate in the tribunal and the commission is high because those resources, those individuals are so professional, so experienced. You'd find, like in particular, law firms will try and poach them as well. So it's quite a difficult thing. So for me, if you ask me, what's one of the key risks of the Competition Tribunal?
Yeah.
I'll say it's resources. It's making sure that we have adequate resources.
Yeah.
And even when I was there, I know how many letters we used to write to the minister as well,
Yeah.
around resources, not just employees on the administration side, but also on the tribunal side as well, tribunal members as well. So it was always a difficult challenge for the staff there in it, to deliver on its mandate as well. So for me, I think that is the key challenge in the tribunal.
Thank you very much, Advocate Oliver. Thank you so much. Advocate Anisa, your parting words.
Thanks. So I wanted to start by saying I agree 100% that there's a lot of challenges, etc. Time-wise, mergers, and I believe that the onus is also on the parties where they don't agree with conditions to voice that they don't agree, but they are accepting it, so that that can, at least that view can be then interrogated further in the tribunal. I am concerned about things like no admission of liability. The Nigerian Coca-Cola case was slightly different because they changed the penalty from a penalty, which is an administrative penalty, to paying for the costs of the investigation, which gave it a very,
different.
I want to say it didn't add any credibility at all to that change. And as the word was used, curiously, but it is what it is. You cannot ignore the fact that there are claimants out there that are waiting for the end of an investigation and waiting for a finding of a liability or a agreement or an admission of a liability, and that this is taking away their, after 5 years of investigation, their ability to then go for a declarator in terms of Section 65 and say, hey, I am entitled to claim damages on the basis that there was a finding against party. And the tribunal has said the matter is not a completed proceedings. There's no finding if there's no admission of liability. So it leaves the party who wants to claim damages to have to take on the big guys in the tribunal to try and get this order. And that just doesn't, again, there's that imbalance there. So that's one of the things that I believe is still concerning and still needs to be considered. And like I said, the things like how are we going to, we look at enforceability of all of these conditions that are not really directly related, but are they really enforceable? So I think that must be considered as well. And then I've mentioned the Supreme Court of Appeal and what the Supreme Court of Appeal has said. And I just want to leave a few parting shots, is that it says, as is happening at the tribunal, each case must be considered on its own merits, and that there must be a balance between the different considerations that are relevant to the exercise of the court's discretion or the tribunal's discretion, in this case, the tribunal. And you must consider, one of the things is whether what you've got is enforceable or not. And I think that's really important. You can get to a settlement, but that settlement must be enforceable. And then it uses the Supreme Court of Appeal uses a very interesting word. They say, it doesn't mean that any settlement order proposed by the parties should be accepted. The court must still act in a stewardly manner that ensures that its resources are used efficiently. After all, institutional interests are not subordinate to the wishes of the parties. And so where it's necessary, it must insist on the changes. And then my last line of parting shot, and it has to come, Judge, from the Nigerian case, which I thought was amazing when they used this particular quotation, which is, the court is not a mere conduit for private compromise and must act to preserve, and this is the three important words, it must act to preserve its integrity, jurisdiction, and duty to the public. And on that, that's my final parting shot.
Thank you for that. and that that judge was the writer of that. So oh, and Jabulani, a last word from you, and then we would have to move on.
Thank you so much, Odie. I think just 2 points from me. I think the first thing I thought I should just mention is, the issue of firms, who appear before the tribunal. These are firms, Odie, who are extremely well resourced. I think if you attend the tribunal's proceedings, you'll see that they receive legal advice from experienced competition law attorneys and advocates, when they appear, when these consent agreements are presented. These firms enter into these consent agreements voluntarily with the commission. And so it is important to note that, and if they're not satisfied with the tribunal's judgment or the order, it is important to note that there is an appeal process where the parties can appeal. And they can appeal the tribunal's decision to the CAC, and parties do that all the time. I mean, the Netcare case, which you opened with, was an appeal against the tribunal's decision in a settlement agreement, in a consent agreement, in a major context. It was appealed. So there is that avenue. So I thought that I should mention that. And the second thing I thought I should mention is a perception, and I think it's because the issue of virtual hearings, and I think before COVID, we all know that the tribunal used to conduct all its hearings in physical hearings in the public, and that was the default mode of conducting proceedings. But after COVID, there are now virtual hearings, and they may be conducted on a case-by-case basis. There is a directive from the tribunal, a chairperson to that effect. And this applies to situations where there are no disputes between the parties. I mean, the last transaction which involved Vodacom was held in open public, and virtual hearings are dealt with in those cases where they are non-complex and they don't require evidence. But whilst that is the case, that there are those virtual hearings, it does not mean that simplementers, the cases which are referred to as simple, are decided in chambers, and therefore there is rubber stamping of those cases. There isn't such at the tribunal. Hence, I disagree, that the tribunal rubber stamps any decision and consent agreements. And also to emphasize that any perception to the contrary overlooks everything that we do, at the tribunal, given the fact that its decisions are preceded by detailed information requests by the tribunal to the parties, follow-up correspondences, rigorous internal debates and deliberation, and sometimes even post-hearing deliberations, as it has happened in the pick and pay consent agreements. And lastly, as Anisa had said, there is a measure which was not even contested at all by any of the parties, where there is a dissenting view by one of the panel members in a measure which was not contested at all. So that judgment, it is there, and it indicates the fact that there is no rubber stamping, and the fact that the panel that is seized with the matter, they do interrogate these issues. There are disagreements amongst the panel members as well, hence you see dissenting opinions as well. So there is no rubber stamping. There is extensive work which goes behind, and the tribunal exercises discretion in terms of the Netcare judgment. Thank you so much.
Thank you very much, panel. It was such a great privilege and a wonderful engagement, and thank you so much for joining us today. I really appreciate it. Judge Thomas, all the way from Nigeria, Advocate Oliver, Jabulani, and Advocate Anisa.